Okay, so today we are diving straight into a pretty significant legal development. It involves one of the absolute biggest names in modern fantasy.
A huge name, globally recognized, but this specific story, well, it stayed remarkably quiet in the mainstream press for quite a while.
Yeah, it really did. And that quietness, that's actually part of the story itself, isn't it? It sort of shows how maybe fame and reach can shape not just the legal fight, but like the public conversation around.
Absolutely. It felt, some sources suggest it felt actively managed or at least deliberately kept low-key.
Exactly. So we're talking about the author Neil Gaiman and specifically the recent dismissal of a sexual assault lawsuit that was filed against him by Scarlett Pavlich to work for him as a nanny.
Right.
And our mission today for you listening is really important. We need to carefully pull apart here. We've got the legal outcome, which, okay, was a win for Gaiman's lawyers on procedure. But we need to separate that from the actual allegations themselves, which are very serious.
That's the core task. This isn't just reading a court docket. We're going to unpack the specific legal language, the why behind the dismissal. Then we'll look at the pattern of alleged behavior that our sources describe. This isn't just about one case, apparently.
Okay.
And finally, we need to analyze the, frankly, sophisticated PR strategy that was reportedly deployed to manage the narrative, how the story was shaped, or perhaps prevented from reaching a wider audience soon.
And it's kind of striking looking at the source material. Gaiman himself went totally silent on social media during all this.
He did.
And our sources say, look, that strategy, it seems to have basically worked. Because even with this lawsuit happening, he's still everywhere.
Yeah.
You know, promoted as the industry's leading fantasy author, big Netflix shows, his name on book covers.
Right. The brand, the business side of things just kept rolling along, almost untouched.
That disconnect is fascinating. The personal silence combined with the professional, amplification.
It's a classic crisis management tactic in a way. Let the legal team and the PR people handle the noise, stay out of it personally, and let the professional success sort of drown out the negative press until you get a result like this dismissal.
Okay, so before we even get to the PR and the alleged pattern, we have to start with the court case itself. Section 1, understanding the jurisdictional because this nuance is everything.
It really is. When people hear lawsuit dismissed, the immediate assumption is often, oh, he was innocent, or the case had no merit.
Right. Vindicate.
Exactly. But we need to hammer this home right away. Okay. That is not what happened here. The judge was incredibly clear about it.
Okay, so what did the judge say?
The judge explicitly stated that the court was not deciding if the allegations were true or false. That wasn't the question on the table.
Not the merits of the case.
Not at all.
Yeah.
The entire focus was procedural. It boiled down to one thing. Was Wisconsin the right place, the right forum, legally speaking, to hear this specific case?
So it was a fight about legal geography, essentially, not about what actually happened.
Precisely, which makes understanding the plaintiff and the claims crucial, because the seriousness of the allegations makes the whole where do we fight this question so significant.
Okay, so the plaintiff, Scarlett Pavlich, she worked as Gaiman's nanny, but only for a short time in 2020, right?
Yes, a brief period, and her claims were extremely severe. She alleged that Gaiman used the promise of employment as leverage to sexually assault her multiple times over several weeks.
Wow. And the legal-based suit.
She filed claims under the Federal Trafficking Victims Protection Act, the TVPA, and also under state common law, things like assault and battery, emotional distress.
And the description of Gaiman in the complaint was pretty stark.
Very stark language.
Yeah.
It depicted him as predatory, cruel, and sadistic. Really strong allegation.
Okay, that TVPA claim, the Trafficking Victims Protection Act. That might sound a bit strange to some people in this context. It wasn't like international trafficking.
That's a really good point. And it's actually key to why they probably filed in the U.S. The TVPA is aimed at modern slavery and human trafficking, yes, but it has civil lawsuits. Oh. And the argument wasn't necessarily traditional sex trafficking. It was more about using power and coercion related to her employment and her ability to stay in the country, New Zealand. In this case, to compel or coerce sexual acts.
So leveraging her vulnerability, her need for the job and housing.
Essentially, yeah. Arguing that this kind of coercion, using the promise of work or the threat of losing it, fits under the broader definition of trafficking for the purpose of a civil suit. It was the legal mechanism, the hook, to try and establish jurisdiction in a U.S. federal court.
Because the alleged events happened outside.
Correct, in New Zealand. So they needed that federal lock, and Gaiman's defense team immediately attacked that hook. They had two main arguments for why the case should be dismissed.
Okay, what were it?
First, the improper forum argument, basically saying this case doesn't belong. Everything happened in New Zealand. Pavlich is a New Zealand citizen. Gaiman had permanent residency there at the time.
Oh, well, the connections point there.
Overwhelmingly, they argue. So the U.S. court, specifically Wisconsin, is the wrong place.
Makes sense. And the second argument?
That one went straight for the federal claim itself, the TVPA scope. They argued that the part of the TVPA allowing civil lawsuits doesn't actually apply to conduct that happens entirely outside the United States, what lawyers call extraterritorial conduct.
Ah, okay. U.S. laws generally don't apply abroad unless Congress specific.
That's the general principle, yes. It's a complex area, but courts are usually hesitant to apply U.S. law outside U.S. borders. And they also argued, look, if you throw out the federal TVPA claim, then the court shouldn't keep the state law claims either.
Right, because there'd be no reason for a federal court in Wisconsin to handle what's essentially a New Zealand dispute based on local laws, like assault.
Exactly. No federal hook. No reason to keep the state fish on the line.
So the judge had these two strong arguments from the defense. How did the court rule?
The judge found that, yeah, both arguments actually had legal merit. There were valid points on both sides.
Okay.
But the dismissal, the final decision, was based on the first point, the location. The judge agreed that New Zealand was the more appropriate forum.
Why? What was the reasoning?
It came down to the balance of convenience, the legal test. The judge looked at where everything happened, New Zealand. Where the plaintiff lives, New Zealand, where Gaiman was living and working at the time, New Zealand. And crucially, where's all the evidence? Where are the potential witnesses, neighbors, colleagues, anyone who could back up timelines or provide context?
Almost entirely, presumably.
Almost entirely. Records of employment, physical evidence, most non-party witnesses. All in New Zealand. Trying to conduct a trial in Wisconsin, flying people back and forth, dealing with evidence from overseas. The judge found it would be incredibly inefficient and burdensome.
So the only real connection to Wisconsin was just Gaiman owns a house there.
That was pretty much it. It wasn't where the alleged harm occurred. It wasn't where Pavlich lived or worked. It wasn't where most of the proof was. The connection was just too thin compared to New Zealand. So the court dismissed it based on form nonconvenience. The form is inconvenient.
Okay, but here's a really critical legal detail we need to explain. The dismissal was without prejudice. What does that actually mean for Scarlett Pavlich? Is the case dead?
This is super important. Without prejudice versus with prejudice. Think of it like this. With prejudice is like the judge saying, game over, you lose on the substance, or there's a fatal flaw. You cannot bring this specific claim again anywhere.
Right. Door slam shut. Permanently. But without prejudice is different. It's procedural. It means that the case wasn't decided on its merits, whether the claims were true or false. It was dismissed because it was filed in the wrong place. So the judge is essentially saying, you filed in the wrong court, go file it in the right court. In this case, the right court is presumed to be in New Zealand. The door isn't shut. It's just been relocated. So she can refile the lawsuit in New Zealand?
Yes, the dismissal allows her to do that. And our sources pointed out something clever the judge included in the ruling, too.
Oh, what was that?
A safety valve, basically. The judge added a condition. Pavlich can ask to reopen the case back in Wisconsin if she tries to sue Gaiman in New Zealand, and he then refuses to accept the lawsuit papers there. Refuses service is the legal term.
So he can't argue, go to New Zealand, and then when she does, suddenly become impossible to find or serve there.
Exactly. It prevents him from playing games with jurisdiction, using the dismissal as a way to dodge the lawsuit altogether in both countries. If he won't face it in the proper forum he argued for, the U.S. door might reopen.
That seems fair. But it still brings us back to the strategy. Why file in Wisconsin in the first place, knowing this jurisdictional fight was likely, maybe even inevitable?
Well, look, there were probably a few reasons, practical and strategic. First, the simple logistics. Gaiman has a known residence in Wisconsin. Serving him with the lawsuit papers there was straightforward. That's often a big hurdle with international figures.
Okay, ease of service. Makes sense. What else?
The bigger issue, and our sources really emphasize this, seems to be the differences between U.S. and New Zealand law on these kinds of cases.
How so? What advantage?
The potentially huge one, the statute of limitations. This is the legal deadline for filing a lawsuit.
Right, the ticking.
Exactly. There's speculation, based on the source material, that the time limit to file these specific claims might have already expired under New Zealand law.
Wow.
But the deadline might still have been open under U.S. law, especially using that federal TVPA claim, which might have its own potentially longer time window.
So filing in Wisconsin, even with the jurisdictional risk, might have been the only way to file the case at all before time ran out.
It's a strong possibility. It could have been a calculated risk, maybe even a bit of a long shot, but potentially the only shot they had left. Filing in the wrong place might have been better than not being able to file anywhere.
That really highlights how complex things get when you have powerful people moving between countries with different legal systems. The defendant's resources and mobility can create huge barriers for an accuser just trying to get their hurt.
Absolutely. It forces the fight onto procedural grounds, geography, timing, rather than the substance of the allegation. The court made the correct procedural ruling based on the law of forum, but again, it specifically did not rule on the truth of Scarlett Pavlich's very serious claims.
Okay, so that's the legal dismissal unpacked. Right. But as you said, this isn't just about one case. Our sources suggest a broader context, a potential pattern. Let's move into Section 2, pattern of allegations and financial settlements.
Right. This is where we step back from the specific Pavlich lawsuit. The sources we reviewed claim this isn't an isolated incident. They mention, I think it was 7 different instances, 7 women who have allegedly come forward with concerns or accusations over time.
7. And the sources draw a parallel to other high-profile cases.
Yeah, they make a comparison, maybe controversially, to situations like, say, Bill Cosby, where initial reports sometimes embolden others who had similar experience out, revealing a pattern that wasn't visible.
Okay. And what's the reported response or defense from Gaiman regarding these other alleged incidents?
Well, the sources claim that Gaiman has, quote, pretty much admitted to a bunch of this stuff, but the key qualifier is his insistence that it was, quote, all consensual.
The consent defense.
Yeah.
So acknowledging interactions occurred, but framing them as mutually agreed.
Exactly. Which immediately shifts the focus. It's no longer about if something happened, but about the nature of the consent, especially when there are, significant power dynamics involved.
Right. Like the employee relationship with Pavlich, or maybe author-fan dynamics, or situations involving financial dependency. Those complicate the idea of free and willing consent, don't they?
Huge. If someone relies on you for their job, their housing, their professional future, or if they're influenced by your fame and status, the legal and ethical definition of consent gets very murky very fast. Coercion doesn't always involve physical force. It can be economic or psychological.
So the sources suggest Gaiman might have leveraged his position.
That's the implication in the source, that his position created opportunities or dependency that were then exploited, even if framed afterward as consensual.
Okay, let's look at the financial angle here. Our sources detail 3 specific incidents, including Pavlich's, where financial settlements were reportedly involved. This seems like a key part of the alleged pattern.
Yes, it does seem central. Let's revisit Pavlich first. Beyond the lawsuit, the sources claim she was separately paid off with hush money and a non-disclosure agreement, NDA.
Okay, a payout plus an NDA. That's pretty standard.
It is standard practice, yes. But the sources immediately raise a red flag. They point out that using an NDA to silence someone about an alleged crime like sexual assault could potentially be illegal or unenforceable as against public policy.
So wait, if the NDA itself might be illegal in this context, why don't accusers just break them and speak out? What's stopping?
It sounds simple, but the reality is brutal. Challenging an NDA means more legal action. The accuser, often already drained emotionally and financially, would have to sue the powerful person again, specifically to get a court to void the NDA.
Facing off against likely immense legal resources.
Exactly. They'd face the threat of camera lawsuits for breaching the contract, even if they believe it's unenforced. The fear and the cost are usually enough to ensure silence. The NDA works as a very effective deterrent, whether it's technically legal regarding the crime or not.
That makes sense. It's a powerful tool for control. What's the second incident involving a settlement?
This involved a fan. The claim was that Gaiman had creeped on her and went a little too far. Details are scarcer here, but the outcome reported is the same pattern. Gaiman settled the claim.
And the settlement included?
Payment for the fan's therapy bills, specifically mentioned, and crucially, another NDA was part of the deal.
Okay, so that's 2 instances now. Alleged misconduct, followed by a financial payout linked directly to therapy or hush money, and solidified with a legal agreement demanding silence.
Correct. It starts to look less like isolated incidents and more like a repeatable process, a standard operating procedure for handling these kinds of accusations privately.
And the third incident, the sources describe this one as particularly disturbing. It involved the wife of a gardener at Gaiman's New York property.
Yeah, this one, the details provided by the sources are deeply troubling. The woman was living on Gaiman's property. Her husband, the gardener, divorced her, leaving her in a very precarious financial state. She claimed she couldn't afford to stay there.
So, completely dependent on Gaiman for housing.
That's the setup. And the core allegation is horrific, that Gaiman made her trade sexual favors in order to live there.
Wow. That's quid pro quo sexual coercion, using basic shelter as the leverage.
It's an extremely serious allegation of exploiting vulnerability. It strips away almost any argument about consent, tying the alleged acts directly to her survival, her housing.
And the resolution, according to...
It followed the pattern again. She was allegedly paid off the figure mentioned as a few $100,000. And of course, she signed an NDA.
Another significant payout, another NDA.
Yes, and the source material adds another layer. It includes a claim from her testimony that these alleged sexual acts occurred even with children around in the room present.
That's incredibly disturbing.
The sources reporting this described it as absolutely sickening. Yeah. Reflecting, in their view, an extreme abuse of power, and a complete disregard for boundaries.
So looking at these three reported incidents together, the nanny, the fan, the gardener's wife, the sources paint a picture of a consistent strat. Address the allegation, pay money, sometimes substantial amounts, and secure silence legally through an NDA.
Across different types of relationships, different contexts, but the same alleged mechanism for resolution. It strongly suggests, according to these sources, a deliberate, possibly long-standing method for managing legal and public relations risks associated with these kinds of claims.
And this brings us to a warning the sources mentioned, the potential for future action based on these NDAs.
Right. There's an expressed concern or expectation in the material that Gaiman might actually try to use these NDAs against the women later on.
How so?
In a retaliatory manner, as the source put it. If any of these women were to speak out further or perhaps cooperate with journalists or future legal action, Gaiman could potentially sue them for violating the NDA they signed.
So the very document meant to close the issue could be weaponized to enforce silence indefinitely.
That's the fear. It creates this ongoing threat hanging over the accuser. Even if they received a settlement, they bought it at the price of perpetual silence, legally enforceable by the very person they accused. It highlights the immense power imbalance.
Yeah, where financial resources can buy not just a resolution, but potentially lifelong control over the narrative.
Even if the underlying conduct was criminal, as alleged, the moment that NDA is signed and the money changes hands, the power dynamic shifts dramatically, and the ability to achieve public accountability becomes incredibly difficult.
It's a sobering thought. This combination of legal maneuvering, financial settlements, and NDAs seems incredibly effective at containing. But our sources say there was another layer to this. A proactive media strategy. Let's get into that in a second. The publishing industry and coordinated PR.
Okay. So the first thing the sources note is how the story initially landed, or rather didn't land. The mainstream media reaction was described as silent and complacent.
Silent, despite a federal lawsuit being filed against such a publisher.
Yeah, it apparently took months and months and months from the initial filing and related reports surfacing privately from major news outlets to actually cover it in any detail.
Why the delay? Was it just missed or something else?
The sources suggest it points to kind of institutional reluctance, maybe fear of backlash from fans, maybe pressure from the publishing industry itself, or just the inertia that sometimes protects powerful, well-liked figures. He's a big name, a valuable asset to many.
A cash cow, let's put it.
Exactly. That term came up. The financial implications of crossing someone like Gaiman are significant. So there was this initial quiet period. What broke the silence, according to the sources?
It apparently took a major respected publication stepping up.
Right, the New Yorker. They published what the sources called bombshell interview at the beginning of the year. And those interviews reportedly showed the gory details of the allegations.
So the New Yorker piece gave it legitimacy and forced other outlets to pay attention.
It seems so. It provided cover, perhaps. Once a heavyweight like the New Yorker ran with it, it became harder for others to ignore.
But even after the story broke more widely, did it stick? Did it have lasting consequences in the industry?
Well, that's where the walkback comes in. The sources say there might have been some initial ripples, maybe publishers pausing projects, some organizations rethinking associations. But ultimately, everything's kind of been walked back. Cancellations didn't hold. The momentum seemed to fizzle out.
And the reason suggested is the money, his value to the industry.
That's the strong implication. When you have a massive hit like The Sandman on Netflix, bringing in huge audiences and revenue, plus decades of best-selling books still selling, the economic incentive to keep working with him is immense.
Creates a kind of protective financial buffer.
A very powerful. For publishers, studios, festivals, the cost of cutting ties might seem far riskier than the potential PR fallout from the allegations, especially if that fallout can be actively managed.
Which brings us to the alleged PR camp. This sounds like more than just standard reputation management.
According to the sources, yes. It was described as a highly coordinated, very expensive effort. They reportedly hired a huge Hollywood PR firm.
A top-tier firm. And what was their objective?
The sources use a really striking term. The goal was to memory hole the allegation.
Memory hole, like erase it from public content.
Essentially, yeah. And to achieve that, they focused heavily on changing search engine optimization, SEO, making it so that when people search for Gaiman online, the negative stories related to the lawsuit and allegations would be buried.
How do you even do that? You can't just delete news articles from the New Yorker.
No, you can't delete, but you can make them incredibly hard to find. It's about controlling what appears on the first few pages of Google results, because most people don't look beyond that.
Okay, so how does the PR firm bury the bad stuff?
Two main tactics report. First, you flood the internet with other content, masses of positive or neutral information, news about upcoming projects, interviews about his writing process, awards, charity work, retrospectives on Sandman.
So overwhelming volume creates so much noise about Gaiman, the successful author, that it drowns out the signal about Gaiman, the defendant.
Exactly. You amplify the brand, the commercial success. And second, the sources specifically mentioned the use of bots to manipulate social media.
Bots. Automated accounts.
Yeah, using automated accounts to artificially boost discussion and engagement around positive topics, like the new season of The Sandman. This pushes those topics up in trending lists and algorithms, while discussions about the lawsuit get pushed down and disappear from view.
So this ties back to Gaiman's personal silence on social media. He didn't need to engage because his PR team was handling the digital battle.
Precisely. He stays quiet, avoiding personal missteps, while the hired guns manage the online environment, ensuring his brand remains highly visible and positively framed. It's a very sophisticated way to control the narrative without ever directly addressing the core accusation.
It's like digital reputation laundering.
That's one way to think about it. Aggressively promoting the commercial asset to obscure the personal liability. If all the online chatter is about the TV show's success, it makes it much harder for the average person or even industry part to keep the allegations top of mind.
And the sources reflected on this overall situation, suggesting Gaiman gets treated differently than others might.
Yeah, there was commentary about him seeming to be in a kind of protected class, that the literary and media establishment might handle allegations against certain figures, especially those seen as, quote, nice feminist liberal men, as one source put it, with more leniency or protection.
Raising questions about impartiality.
Exactly. Does immense cultural capital and financial success buy a different standard of scrutiny? That's the question hanging in the air, based on this source commentary.
So when you put all three pieces together, the jurisdictional legal win, the alleged pattern of NDAs and settlements, and this intensive PR campaign, it paints a picture of a multi-layered defense.
It really does. A system leveraging legal expertise, financial resources, and sophisticated media manipulation. The dismissal wasn't just a courtroom event. It was, according to these sources, the outcome of a comprehensive strategy designed to control both the legal process and the public perception, ensuring the allegations themselves got buried.
Okay, let's try to summarize the key takeaways for you, the listener. 3 main threads emerge from this deep dive into the source material.
First, the lawsuit dismissal was purely about jurisdiction. The where, not the what. The judge decided Wisconsin wasn't the right place. New Zealand was. Critically, this was without prejudice, meaning Scarlett Pavlich can still pursue the case in New Zealand, provided Gaiman cooperates with being served there. It was not a ruling on the truth of the sexual assault.
Got it.
Second, the sources detail a concerning alleged pattern involving multiple women, 7 instances mentioned. This pattern reportedly involves financial settlement, sometimes substantial, consistently coupled with non-disclosure agreements, NDAs, designed to enforce silence, often in situations involving clear power imbalance.
Okay. And the third?
Third, the public conversation around these serious allegations was subject to what sources describe as an aggressive, expensive, and coordinated PR. This involved hiring a major Hollywood firm, using SEO tactics and potentially social media bots to memory hole the negative information, burying it under a flood of positive content about Gaiman's professional success.
So what this really shows us is how things like legal geography, where you sued, combined with media influence, deep financial pocket, can basically dictate whether and where justice is sued.
Yeah, for the person making the accusation, suddenly the defendant's travel schedule or the statute of limitations in different countries becomes a bigger obstacle than the actual facts of their claim. It's a stark look at how power operates in these situations.
Which leads us to our final provocative thought for you to mull over. It comes back to those NDAs. The sources claimed they might be illegal or unenforceable if used to cover up a crime, and also warned Gaiman might use them retaliatorily against the women. So think about this. What does it mean for accountability if someone powerful can use a settlement agreement potentially signed under duress or based on covering alleged criminal acts as a weapon to re-victimize or silence accusers later on by threatening lawsuits against?
It turns the very tool meant to provide resolution into a potential instrument of ongoing control and intimidation. If settling means living under the constant threat of being sued again for speaking out, even about potentially illegal acts covered by a potentially illegal NDA,
what pathway is truly left for accountability, especially when facing someone with seemingly limitless resource to enforce that silence?
The deeply troubling question about the effectiveness of our current system to handle kinds of power.
Definitely something profound to think about. Thank you for taking this deep dive.